Welcome to Southwest Florida Real Estate Update, hosted by area realtor Jim York and York Real Estate Group of Downing Fry Realty. Our show will bring you the most up-to-date information about the local real estate market, featuring leading experts in the real estate field.
Hi, welcome to the Southwest Florida Real Estate Update. I'm Morgan York with the York Real Estate Group, and today we're joined by our host Jim York and his guest Celia Deifik.
Thank you, Morgan, for the introduction. Well, thanks for coming on the show today. Let's tell our viewers a little bit about your background a little bit here in Naples.
Sure. I've been practicing law for over 30 years. I'm board certified in real property law since 1990, which involves recertification every 5 years. I focus my practice on real estate litigation. I'm with Lanier and Deifik downtown Naples, and I think that pretty much sums it up.
Well, that's good. Well, we recently had a hurricane here.
Oh, yes.
So we went through it fairly well. But, you know, when we have people coming in and doing work on their houses and, you know, there's associations, there's debris and contractors, we could have some litigation because things weren't done properly or whatever the case. Maybe the people weren't licensed properly. So where do we start in a litigation? Maybe why don't you just start there?
Well, let me try and address your initial concern about contractors coming in. I think people need to be cautious, particularly about fly-by-night types who are driving around in a pickup truck doing work for cash. You're going to have difficulty getting insurance proceeds for that. You're going to have difficulty making a deduction on your income tax return next year because casualty loss deduction rules have changed for homeowners' benefits, and we'll discuss that a little bit more. But you also need to be cautious because these people may not only not be licensed, but they may have no insurance themselves. So if they cause harm to your property, or God forbid someone gets hurt.
That's right.
They have no insurance, and it's going to be on your homeowner's insurance. And particularly with power lines down and all of the problems we've had, I urge people to be very cautious. Further, the law requires that if you're entering into a residential construction contract, the contractor has to give you very specific disclosures in the contract, in any residential contract, so that the homeowner is aware of not only the possibility, but in some instances probability of construction liens. And people who are working for cash are not going to be giving you those appropriate types of disclosures.
Yeah, so basically, you know, when you have something what we just had, everybody's in a rush to get everything done, which it's just our human nature. So,
sure.
So there should be, you know, they should be a little bit cautious or a lot cautious about getting the proper documents with a contractor.
Yes.
Because if somebody, like you said, gets hurt or whatever, it falls back on you, and whoever has the most money, they're going to have
everyone's out looking for a deep pocket defendant, and I guarantee you that the two guys in a truck are going to be long gone.
That's right. Yeah. Right. So in a lawsuit, if God forbid something like this happens, what is the consideration to start the process?
Well, I think that we have to be very cautious now. After Irma, we're going to have possibly a lot of a lot of litigation arising from construction defects which were revealed or alleged to be revealed by the hurricane. We're going to have a lot of disputes between community associations and their unit owners. We're having litigation now arising out of residential contracts that didn't close for whatever reason, and the list goes on and on. But I think there are some unifying themes that you want to think about when you go and talk to a lawyer and discuss whether you should file a lawsuit or not. The first is attempt negotiation. It's always wise to try and get, and it's economical,
Right.
try and get things resolved before you get into litigation. Furthermore, I think people don't realize that it looks better to the court if you can prove that you made efforts to work things out before you rush to the courthouse. But if you must file a suit, then there's things you need to think about. And you need to think about these even while you're negotiating. Timing is very important. I tell people, yes, it's important to try and negotiate. It's important to try and resolve things. Sometimes time heals all wounds. But time can work against you too, because in Florida, as in most states, we have deadlines called statutes of limitation. And if you don't file within those deadlines, you can lose your right to bring a lawsuit at all.
How long are those?
Well, they vary as to
Right.
the type of case. If it is what we call a tort personal injury case, you have 4 years. With regard to contracts and negotiable instruments, and of course a lot of real estate would fall into that, real estate disputes, you have 5 years. If you're trying to obtain specific performance of a contract, in other words, you promised to sell me your house and now you have cold feet, but I really want the house.
Right.
And I want to force you to convey the house to me, give me that deed, that specific performance, I have to bring that within 1 year. So some of these limitations are pretty short. Other things to think about are you may want to file a suit on a lien. Let's say you're a condo association or a homeowners association, or you're a contractor or a subcontractor and you want to file on a lien. Liens expire. They expire usually within 1 year.
That's right.
There are some variations, and so you should get an attorney to look at this closely for you. But I have seen lawsuits thrown out because they were brought on liens that expired maybe a week before, maybe 6 months before.
But liens can be renewed, right?
In certain circumstances, they can. It has to be done appropriately. For instance, in the condominium context, the condominium cannot recover attorney's fees unless they have first given notice. There's certain notices that must be given.
That's right.
And I've recently had a case where they brought suit on a lien that was based on a notice from 2 years ago of a delinquency that had been cured. Well, that lien is going to be invalid. So you don't want to wait too long. The other considerations that you need to think about are, particularly with regard to real estate, and I focus on litigating real estate and related business issues. If you are bringing a suit to try and get title to property and you're not already entitled, like the specific performance example I was giving you, if you do not file suit and then record a lis pendens in the public records, you can file the suit, but the property may have already been transferred to someone else.
Right.
And the whole point of the exercise may be futile. The other thing is, and it sounds kind of silly, but it's really true, you need to think about the health and the whereabouts of the parties to the suit and witnesses, because people move and witnesses die. I had a case once where we had a very good case. Our key witness, during the length of time that it took for the suit to work its way through court, developed dementia. And he couldn't remember the pertinent facts. And it was a pretty hard blow.
Well, we're going to take a little short break and take a little commercial about the
Okay.
York real estate
All
team
right.
here, and then we're going to come back and talk about the cost of filing a lawsuit. Okay?
Sure.
We'll be right back. Thank you.
Thinking of buying or selling a home in Naples, Bonita Springs, or Estero? Think of the most experienced realtors. The York Real Estate Group of Downing Fry Realty. Let's have a look at what the McLeans have to say about their experience working with the York Real Estate Group.
Jim York was our broker in acquiring our present home in Bonita Springs. His knowledge and integrity made the process go very smoothly.
It was a pleasure doing business with Jim York. Everything was done in a superbly professional manner.
Welcome back. Let's talk about the different alternatives there are that you can
Sure.
do rather than filing
A lawsuit.
right up front.
Right. I think it's wise to consider what we call alternative dispute resolution techniques, and I'll explain what those are. It's wise to send demand letters, but people should be aware that sometimes it's mandated by the relevant law. So people will sometimes say to me, I don't want to bother with writing him a letter, and I don't want to bother with going to mediation. And I have to tell them, the court will not entertain your lawsuit
Until you do that?
until you do that in certain circumstances. First of all, it's wise to do it. Second of all, it may be required. There's three primary types of what we call alternative dispute resolution. One is mediation. Mediation is where you bring in a third party, often an attorney, but it can be an accountant, an engineer, whoever has knowledge of your particular circumstances, to sort of act as a buffer or a referee and see if you can come to some kind of a agreement. The mediator doesn't have the power to force a settlement, but sometimes a good mediator can make each party see the weaknesses in their position and get it over with. Now, you can do a mediation before a lawsuit. Often the court will require you to do a mediation or an arbitration before you go to trial. And that's after the lawsuit's been filed.
Right.
So let me talk just briefly about arbitration. Two types of arbitration that we see in Florida. The non-binding arbitration is what courts may often compel parties to try, at least try, before a trial. Non-binding arbitration is with an arbitrator. Again, can be a lawyer, engineer, accountant, whoever has that kind of expertise. And that person does have the power to make a decision. We call it non-binding because if a party is not happy with the decision, they still have the right to demand the trial. The catch is if they demand trial and then lose, they're going to wind up paying everybody's expenses, including attorney's fees, from the time of the trial. From the time of the decision in the non-binding arbitration. Some contracts provide for binding arbitration, and that's basically a private trial. The arbitrator's decision is the final decision. In either type of arbitration, the arbitrator's decision is given to the judge, and the judge incorporates it in a final judgment, so it has the strength of the court behind it.
How about the cost? What's the cost?
Well, the cost of mediation is considerably less. And of course, if you do these things before trial,
Right.
you can save a tremendous amount of money. Often people come to me and they're very emotional about the principle of the thing. And I say, you know, if it's about the principle of the thing, I'm automatically adding $10,000 onto your fee. Because dispute resolution should be about making intelligent, rational decisions that help everyone move forward with their lives. I'm a very aggressive person, but I'm not interested in spinning my wheels for malicious purposes.
Right.
So if you go to an attorney and you sit down and you want to talk about fees, things you should ask: will I be entitled to an award of attorney's fees from the other party if I'm successful? Remember, if the answer is yes, that works both ways. So if you lose, you can wind up paying your attorney's fees and their attorney's fees. How much will it cost? A competent trial attorney can sit down with you and develop a litigation budget that will give you an idea of what you're spending through each portion of the litigation. Other things to think about are court costs, which are not inconsequential.
Right.
Filing fees keep going up. Lot of little things that add up. And then you need to think about what kind of award are you going to get. Let's say your attorney says, you're absolutely right, and you are 90% sure to win. How much of a damage award can you prove, and will the court give you? Is it going to be worth all of that effort? And then the next question, which to me is often the most important, if it is a money damages case, can you collect it?
Right.
If you can't collect it,
It's a waste of time.
it's a waste of time.
It's a waste of time.
Right.
And what is binding and non-binding?
Well, as I was saying earlier, Florida law provides for two different types of arbitration. Non-binding arbitration is, to some extent, a creature of the statute and a creature of the legislature, and it's an effort, just like offers of settlement and offers of judgment, which are another very clever legislative tactic, to try and get people to settle cases.
Okay.
Really, that's what it's all about. So a non-binding arbitration, you don't have to accept the arbitrator's award, but if you go to trial and lose,
Sure.
you're going to get slammed. Same thing with an offer of settlement. If someone makes an offer of settlement or an offer of judgment, you've sued me.
Right.
And I say, you know what, Jim, you're right. I offer you $50,000 to settle this case.
Mm-hmm.
And that's done privately. The court doesn't see that.
Right.
And you say, no, you owe me $500,000. I say, okay, fine, let's go to court. If we go to court and I win, you could have had the $50,000.
1,000, right.
Now you're going to wind up paying me all my attorney's fees, even if the contract or relevant law didn't provide for attorney's fees. And that's a critical point that I'd like to emphasize. You are not automatically entitled to an award of attorney's fees from the other side, only if it's in the statute that you're proceeding under or it's in your contract. The great thing about Florida is Florida legislature has said that any contract that only gives a unilateral right to attorney's fees has got to be reciprocal. That's a fancy way of saying, if you gave me a contract that said, if we go to court and I win, Celia, you have to pay my fees, but if you win, you don't get anything. The legislature says, no, no, no. It's going to go both ways.
How about venue and privacy?
Well, that's an interesting concept. It's not helpful when you are concerned with real estate, because if you're litigating over real estate, you generally have to litigate. You must bring the case in the county where the real property is located.
Right.
You have no choice. But if you're litigating over money, there are a lot of venue provisions that say you should bring it in such and such place. You should bring it in the county where the contract was formed or where the
Right.
debtor, there's a lot of things like that. But I will tell you that in divorces, nasty business disputes, things of that nature, where people really don't want to air their dirty linen where all their friends and neighbors
That's right.
are, they can agree between themselves, let's go litigate this out in Hendry County and we'll go to the LaBelle courthouse. But the parties have to agree.
Interesting.
Yeah.
I didn't even know that. Not that I'm an attorney either, but how about pleadings? Can kind of wind it up here with that.
Sure. People get confused, I think, between pleadings and motions and things like that. And without getting too technical, pleadings are where you set out the meat and potatoes of your case. Here's the basic facts, and here's the law that we think is applicable. and then the other side can do their pleadings. And those often get amended as we go through the case because people learn more.
That's right.
I think one thing that I would like to say is people have very significant misunderstandings about discovery, which is different than pleadings. Discovery is a fancy word for we get to find out everything.
Right.
Show me all the papers, show me all the models, show me everything you got. We so often have people come in and say, okay, just tell him these things, but don't tell him that, and don't let him see these papers. Well, the discovery process is 100%. It's all going to be revealed. And I think people are confused between attorney-client confidentiality and what happens in discovery. If you want to keep something secret, you probably shouldn't be bringing a lawsuit.
Yeah. Well, let's hope we're not in a lawsuit. So, well, I appreciate you coming on the show today. I've
Okay.
learned a lot about
right.
lawsuits, and I'm sure our viewers have too. And I hope you come on again.
All right, thank you.
Thank you very much.